I don't think we spend the next 3 years scouring the state of New Jersey. We could possibly find two more talented, experienced criminal defense attorneys. Both of these gentlemen are certified criminal trial attorneys by our Supreme Court. Each of them brings to the table an enormous wealth of experience in the practical aspects of doing a criminal trial. And today, they very graciously consented to giving their time to discuss a topic which is of indispensable importance to the criminal trial practitioner, and that is persuading a criminal jury. Let me introduce our two panelists. First of all, this very handsome young man with the glasses is Robert Obler, certified criminal trial attorney with offices in Mercer County. And the elderly gentleman sitting over there is
Keep it up, I can't hear you.
Joseph P. Rem Jr., certified criminal trial attorney with offices in Hackensack. All right. We are here today to discuss the law, the art, and the science of jury persuasion. So let's get right into it. On stage, always on stage. So my question to both of you is, to what extent should you always keep in mind that you're on stage? I just want to preface this, Joe, with a little comment to you. You told a story one time about how you make it a habit. I wish you'd tell the story when you're going to sidebar and the judge is screaming at you and calling you scum, how you react to that for the benefit of the jury. Could you talk about that a little bit?
Well, sometimes when you go to sidebar, the judge is on your side, sometimes he's not. But the important thing to remember when you try a criminal case is that jurors believe that the judge has been the judge for a long time. He has wisdom. He knows whether the defendant is innocent or guilty. And if he rules for you, that's a sign that the judge favors you and your client. And if he rules against you, then the judge knows that your client's guilty and he wants to make sure that your client gets convicted. I mean, it's subtle. And I'm not saying they think this consciously, but certainly the man in the black robes or the woman in the black robes, their attitude towards you plays a part, and more than a minor part, in the outcome of the case. So when I go up to sidebar, and on rare occasion, a judge will not understand the nature of my objection and rule against me. Listen, not everyone is bright enough to understand the nuances of the law. But of course, we're at sidebar, and so everything is done very quietly. And when the judge is telling me, Mr. Rem, you're dead wrong, you're off base, blah, blah, blah. All I know, the jury can't hear that, but they can see me. And I'm always in a position, so I'm facing the jury. And I'll be doing this. Things like that. And so the jury knows that the judge is agreeing with me because I'm nodding and happy and I'm smiling. Even though I just got my ass kicked, the jury thinks that the judge agreed with me. So when I leave there, before the judge can say sustained, I'll just simply move on to the very next question. So yes, you're always on stage, and even something as simple as a sidebar can ingratiate you with the jury.
Joe, one of the things you do is you'll go back and make a signal to your client, like, oh, everything's okay.
As I leave the sidebar, I'll turn to my client so the jury can see me go, some positive and affirming. He has no idea we just got our ass kicked. But that signal to him, first of all, boosts his spirits, and normally it's a his, hardly a her. But the jury sees that and they say, oh, he did good. The judge must like him. He must be smart. He must be right. And if he's representing this man, the man must be innocent.
Do you believe, Joe, that there should be a sense, though, in the trial practitioner that you're always on stage from the beginning of jury selection all the way through the end of the trial, no matter what's happening in the courtroom, that you're on stage? Do you think that that's something that you should keep in mind?
Even when the jury's walking in and out, you have to be aware of what you're doing and what you're saying. My desk, for instance, I have books on my desk. They're always neat stacked. I don't have papers strewn around. Jurors equate organization with firmness of mind. And I figure if you're organized and your desk looks neat, you must know what you're doing. So even something like that, I think, is important.
Bob, what do you think about this topic?
I think it's important to comment on one thing. I have never, ever met Joe prior to this morning.
But that was purposeful, by the way.
And but I want to tell you something about sidebars. What he just said, I'm sitting here smiling because I guess it's written in the criminal defense handbook. I do exactly the same thing, but I even take it one step further. Or maybe
I'm about to learn.
A few steps further. I have a habit. Whenever there's a sidebar called, and sometimes, the prosecutor, if they're going to lose something, they always call it, or if it's during jury selection, And let me use jury selection. You always want to get as many sidebars as you can during jury selection. And I'll get into why in a moment. But one thing I always do is I wait after the sidebar is called. Why? I want the court reporter to go first. Jury thinks you're being considerate, you're being a gentleman. Most court reporters tend, at least in the old days, they were women. And in criminal cases, they're still used. And then I let the prosecutor go. Why? The judge walks down from his little perch and is facing you, back to the jury. Court reporter goes in her little corner. Prosecutor goes in next to the judge. Thinks that's a good place to be. Where do you want to be? You want to be in front of the judge, looking at what? The jury. And it's real easy to do. Think about it. I do it all the time. Why? So when you make the movements that Joe referred to, the jury sees only you. So I always think that's the way to go. When I leave sidebar, I always back up. I let everybody else go first. Same way.
I do the same thing.
I always say thank you, even if I just got my ass kicked. But then I sit down and I usually put my arm around the client and I very nicely say to him, keep smiling, we just got our ass kicked. But I explained it and I say don't show anything. It's a great habit to get into at sidebar. It's an easy habit to get into.
Bob, can you talk a bit generally about the concept of being on stage?
Okay, my theory has always been, and early on, I spent 10 years with the public defender from 80 to 90, basically. And we always taught new lawyers, and anybody who doesn't do it, I think it's close to malpractice. We would take them into a courtroom, and we would say, this is your stage. This is your stage. Remember it. You're always on stage. And we would start from the moment, what you do from the moment the jury walks in, because we really don't care pre-trial. You know, you can wear jeans and yell at the judge as long as nobody's watching. And those are the jurors. And we would explain what a courtroom is. We would explain sight lines. We would explain to each individual where not to go, where you're blocking. And the other thing I would suggest, I don't want to take up too much time, is that every time before you're going to try a case, and I don't care where it is, whether it's Mercer, Hudson, Bergen, anywhere, you're going to be in that courtroom at some time prior to trial. Go sit down in the witness box. Go sit down in seat number 1 in the juror's box, seat number 7, 8, and 14. You'll see the sight lines. Because you cannot understand the stage unless you understand what the audience is seeing. And they are the only audience that you care about.
Now, Joe, do you think that's a good idea?
You know, it's frightening because I've been doing this for years and giving seminars on this and trying cases. I've never, as many times as I've spoken to attorneys, he has spoken every single thing that I believe in and that I do, and I thought that was unique. Just something, it's not something you read about, it's just something that becomes obvious to you as you try cases. He just spoke my life, so I have nothing to add to that.
All right. Well, it's been a short seminar, guys. Thank you. Now, this business about being on stage, I just want to kind of stress that this is just as important during jury selection as it is during the course of the trial, is it not?
It's probably more important during jury selection because the jury, you know, first impression is the only impression. And the impression the jury gets of you as a professional has to be from the beginning on. And one of the things I always did is I would always explain to my client, even if the client was a lawyer, which I've had the misfortune of sitting next to lawyers.
You don't mean people who are trying the case with you? Mean
no, I don't mean people who are trying the case. People who are commonly referred to as defendant. You have to explain what to do when they're introduced, where to turn around, what to say, what not to say. And I actually have rehearsed it with people. I said, judge is going to call on me. I'm going to introduce you. Here's what I want you to do. Why? It's the first time the jury is seeing both you and your client, and he's not my client. So it's important.